Good morning, ladies and gentlemen. I'd like to welcome you to the County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court today for a criminal case. And the criminal case that we have in this court are classified as misdemeanor criminal cases. Criminal cases are divided into felonies and misdemeanors. The felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. The person is convicted of a second-degree felony. The range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony offense, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case. Those cases I just mentioned are felony cases. And so you don't have to worry about that type of punishment. Misdemeanor cases are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, they cannot be given jail time. They only could be given a fine, and the fine cannot exceed $500. Now, your Class C misdemeanors are cases that start in the JP court or the city court, and they come to this court when a person is found guilty in the JP court or the city court, and then they appeal their case, and then it comes to this court. When their case is appealed, yes, you're here. County court too? Yes. You can have a seat in one of the chairs that have the clipboard. Now, when the case comes to this court, after it is appealed, you get a whole new trial. And in essence, you start from square one. Now, and the punishment range does not change. It stays the same. It cannot exceed $500. You can't be given jail time. Now, if you fail to pay the fine, or if your fine was was converted to community service and you fail to perform the community service, then the court can issue what is called a capias pro fine, which means that it's a warrant for your arrest to pay the fine or sit the fine out in jail, and you'll receive $100 credit for every day that you sit in jail. Okay? Now, the next highest misdemeanor, that was a Class C misdemeanor. The next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days or 6 months in the county jail. You can't be sent to the state penitentiary. Okay? You'll be sent to the county jail, and you cannot be sentenced to no more than 6 months or 180 days, which is 6 months. All right. Or you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement, which is jail time. Now, the highest misdemeanor is a Class A misdemeanor. The range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. So when you look at the difference between the Class A and the B, is just the A doubles, the punishment doubles the amount of a Class B. That's one way to look at it. Now, you may be eligible for probation. There are two types of probation that a person can receive. One type is called unadjudicated probation, and the other type of probation is called adjudicated probation. So you have unadjudicated probation or adjudicated probation. Now, unadjudicated probation is normally referred to as deferred probation or deferred adjudication. Same thing. With that, you don't have a conviction on your record. And if you complete the probation, you won't have a conviction on your record, and your case will be dismissed. And you may qualify for what we call a non-disclosure. What a non-disclosure is, your record is sealed. Yes, it's sealed to the general public. They can't go in and look at that offense. Now, the operative word that I used was general public. The general public cannot have access to it. However, the certain governmental agencies can. It is listed, they are listed in the Texas Code of Criminal Procedure. But most of the public is the general public, so most of the public cannot have access to it if you have a non-disclosure. All right. Now, the other type of probation is called adjudicated probation. We have unadjudicated probation. Now we have adjudicated probation. We usually call that regular probation. Now, with adjudicated probation, it does result in a conviction on your record. However, there's something that is called judicial clemency. That means the judge, the judicial branch, the judge can set your conviction aside. You will no longer have a conviction. And the way it works is you have to, one, successfully complete the probation. Two, there cannot be any more time left on the probation. And three, you have to be successfully discharged or let off the probation from the probation department. Once those three things happen, then the court has the discretion to set your conviction aside, and you will no longer have a conviction. Now, if you get a subsequent conviction, which means that if you get another conviction later on for another case, this case that you receive judicial clemency on can be brought back up, it can be resurrected, it can be revived, and it can be used against you. And if you try to get a license, let's say you try to get a license with CPS, Child Protective Service, they can deny giving you a license, or if you have a license, they can revoke or suspend the license. All right. Now, everyone should have a clipboard. I'm going to go over that clipboard with you. And we're going to talk about, now this is arraignment. This is your first appearance in court. And this is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the first right that I'm going to go over is your right to have an attorney. On that clipboard, the first page, the first full page is titled Judge's Explanation of Rights to Defendants Without Attorney. Make sure everybody's looking at that document. I'm going to go through that document. And it states that as a defendant in a criminal case, you have three options. Three options what? Regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you if you cannot afford to hire an attorney. And number three, you may represent yourself. In essence, you can waive your right to have an attorney, give up your right to have an attorney, you can represent yourself. Those are your three options. Now, the first paragraph below number 3 states that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date to give you time to hire an attorney. The next paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first sign an affidavit or a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, if we just stop right there, the questionnaire is on that form. It is titled, you got to look, it's a 3-page document, just turn to it. It's titled Jefferson County Affidavit of Indigence. And the document looks like this. Okay, that's it. It looks like this. Now, for those individuals, this is only for individuals who will be requesting a court-appointed attorney. If you're not requesting a court-appointed attorney, you don't need to worry about this. All right. If you're requesting a court-appointed attorney, you will fill out the first page, and then when we turn to the second page, you will fill out the top portion of the second page that is titled Defendant's Oath in bold letters at the top. And you'll go down to the middle section of this document and you'll fill out the portion that is titled Unsworn Declaration by Defendant, and then you'll stop. All right. Now let's go back to the judge's explanation at first form. On the judge's explanation, the next paragraph states that you may not speak to the prosecutor about your case unless you first sign a waiver of counsel. Now, that is only for individuals who will be representing themselves. If you don't want to have an attorney, you want to represent yourself, you would have to sign a waiver of counsel. Now, for those individuals, the waiver of counsel is another document on that clipboard that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. Only people who are wanting to represent themselves will sign this. If you want to hire your own attorney, you don't have to sign this. If you're requesting a court-appointed attorney, you don't have to sign this. You don't even have to read or sign. Okay? Yeah, this is only for people who will be representing themselves. Okay? You have to read and sign this document and date it. All right. Now, at the bottom, go back to the first document. At the bottom, not at the bottom, but toward the bottom, there's a paragraph in block form right here. That paragraph is for people who will be representing themselves. They said, be aware there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of firearms, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, this last one-sentence paragraph states that if you choose to proceed without an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you decide, hey, I want to waive my right to an attorney. And if you waive your right to an attorney, you're representing yourself, you're acting as your own attorney, and you'll have an opportunity to talk to one of the prosecutors. Now, the prosecutors are assistant criminal district attorneys. Right now, we have 2 of them in court. You'll have an opportunity to talk to them about your case. Why? Because you represent yourself. You're acting as your own lawyer. If you had a lawyer represent you, you couldn't talk to them. Your lawyer can talk to them. Okay? But in this case, you'll have an opportunity to talk to one of the prosecutors. Now, you can talk to them about your case. If they may offer you a plea bargain agreement, they may say, well, you served 2 days in jail we're gonna give you credit for time served, which means you don't have to serve no more time in jail in case the basically over. You can do, and then you can say, okay, I accept that. Or you can say, well, I don't like that deal. And you can say, well, Judge, I want a court-appointed attorney. Okay, you can do that. Then you can apply for a court-appointed attorney. Okay. Now, at the bottom of this document, in bold letters, it states defendant's choice. Now, everybody's gonna make one choice. You're either gonna make a choice to hire your own attorney, or you're gonna make a choice to apply for a court-appointed attorney, or you're going to make a choice to represent yourself. So everybody is gonna fall in one of these categories. All right. So if you would like to hire your own attorney, then you will place your initials on the first line to the left of this document. At the bottom. If you want to hire an attorney, that's where you place your initials here, you'll sign and date it, and that's it. You don't have to fill out and sign nothing else. If you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left at the bottom. That's for individuals who would like to apply for a court-appointed attorney. And once you sign and date, then you will fill out this document that is titled Jefferson County Affidavit of Indian. Fill out the first page. Go to the second page where it says defendant oath. You fill that out. And then you go to the middle page where it says unsworn declaration by defendant. You'll fill that out and then you'll stop. Now, for individuals who would like to represent themselves, okay, you will have to place your initials on the fifth line to the left, the bottom line to the left, the fifth line. And then you'll sign and date it. And then you'll get this next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. So you would read and sign this document. And then you'll stop. Okay. Anybody have any questions? Okay. I know we have this young lady that just came in late. And we have this document that I just went over on that clipboard. It should be the first page. Jefferson County Affidavit. It's titled Judge's Explanation of Rights to Defendants Without Attorney. And on this document, it explains to you what your rights are. It says as a defendant in criminal case, you have three options. And it listed 1, 2, 3. Number 1, you may hire an attorney. Number 2, you may request that an attorney be appointed to represent you if you can't afford to hire an attorney. Or number 3, you may represent yourself. And the first paragraph below number 3 says that if you want to hire an attorney, then your case will be reset, which means you'll give another court date to give you time to hire your attorney. And the second paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, then you can ask that a court-appointed attorney be appointed to represent you. But you must first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. And the financial questionnaire is a 3-page document on that clipboard that is titled Jefferson County Affidavit of Indigent. You would have to fill out the first page of that document, and the second page, you fill out the defendant's oath and the unsworn declaration in the middle, and then you stop. Now, if we go back to the judge's explanation, it states in this paragraph that you may not speak to the prosecutor unless you first sign a waiver of counsel. That is only for individuals who will be representing themselves. So if you're representing yourself, you have an opportunity to talk to one of these 2 gentlemen who are assistant criminal district attorneys, they are prosecutors, and you can talk to them about settling or reaching a plea bargain on your case. Now, you should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities. relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, this last sentence at the bottom, right here, states that if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of this document, you make a choice. It's in bold letters, and it states that defendant's choice, mark your initials to only one choice. Number one, if you would like to hire your own attorney, you place your initials here, sign the document, and date it. If you would like to apply for court-appointed attorney, place your initials on the third line, sign it and date it, and then fill out the Jefferson County affidavit of insurance. If you would like to represent yourself, place your initials on the fifth line, sign and date it, and then you will sign this document that is titled Waiver of Counsel. Okay, now I'm going to give everyone time to fill out the document in a few minutes. I need to go over some more rights that you have. One other right that you have, you have a right to enter a plea of either not guilty, guilty, or no contest. If you enter a plea of not guilty, you're telling the court that you didn't commit the offense that you've been charged with. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or if you enter a plea of no contest, or no contendere, which is no contest, you're telling the court that you will not be fighting the charges. All right. Now, if you enter a plea of not guilty, you have a right to have a trial. And you can have a trial by jury, where those young people are sitting in that area where those 12 chairs are seated. We call that the jury box. 6 citizens from Jefferson County will be selected as jurors, and they will listen to all the evidence, listen to the arguments of the attorneys on both sides. They will go in the back room to deliberate, and they will decide to find you either not guilty or guilty. You also have a right to waive or give up your right to have a jury. In essence, you pleaded not guilty, but you don't want to have a jury trial. You can waive or give up the right to have a jury trial. If you waive or give up the right to have a jury trial, then you have what we call a bench trial. A bench trial is a trial by judge only. The judge sits on the bench. So it's a trial by judge only. The judge will be the judge and the jury in the case. The judge will listen to all of the evidence. The judge will listen to the arguments of the attorneys. The judge will apply the facts of the case to the law. And then the judge will decide whether to find you not guilty or guilty of your offense. Now, you also, another way your case can come before the court is by way of a plea bargain. Now, in order for us to get to a plea bargain, you have to enter a plea of guilty or no contest. Okay? In order to get to a trial, you enter a plea of not guilty. All right? So you enter a plea of guilty, no contest, then your case will come before the court by way of either an agreed plea bargain or an unagreed plea bargain. Now, I'll explain it to you. An agreed plea bargain simply means that you and the state of Texas, or your attorney in the state of Texas, have reached an agreement to settle your case. Okay? For example, I gave you a little scenario earlier about having 2 days, and then that's what they was offering, and you could either, if you accept it, that means you're agreeing to it. Now, if they make an offer to you and you agree to it, then it comes before the judge. And the judge can do one of two things. The judge can accept that agreement or reject that agreement. Now, if the judge rejects your agreement that you made with the district attorney's office, you can tell, well, judge, since you're not accepting that agreement, I take my plea back. I'm not entering a plea of guilty or no contest to this charge. You have a right to do that. All right. Now, if the judge does accept the plea bargain agreement, And within 30 days, you say, you know what, I think I've been wrongfully convicted, or this court committed an error by convicting me. I like to appeal my case. And that's what I like to have a higher court to look at this case. You have to get permission from the judge that accepted your plea bargain agreement. If the judge gives you permission to appeal your case, then your case will leave this courtroom and your case will go upstairs on the third floor to the Ninth Court of Appeals. There are 4 judges up there. They'll review your case. They will decide whether to grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, well, you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals in Austin, Texas, which is the highest criminal court in the state of Texas. Now, you would have to file what is called a petition for discretionary review, a pro se petition for discretionary review. I'll explain that to you. Pro se means you by yourself, you represent yourself. You don't have a lawyer representing. That's what pro se means. Petition for discretionary review, you're petitioning that court, the Texas Court of Criminal Appeals. You're asking them or petitioning them to review your case. Now, if they can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty. Okay, so, or they can send the case back to the Ninth Court of Appeals with orders and send it back down to this court with orders. Now, if they deny your pro se petition, then at that point, your conviction will stand. All right. Now, the other type of plea bargain, I mentioned to you, there's something that's called an unagreed plea bargain. Let's say you and the state or you and your attorney have talked, they worked out a plea bargain, they say, well, we want to give him 120 days in jail, right? And you say, well, I don't like that, I don't want that deal, but I want to plead, so I want the judge to decide what my punishment will be, okay? We call that unagreed. The judge will decide what the punishment will be within the punishment range. All right. Now, the other right that you have is a right to have witnesses to come to court. If you go into trial, you have a right to have witnesses to come to court. They sit in that chair that has the microphone in front of them. That's called a witness stand. They can testify for you or against you. If you represent yourself, you can ask some questions. If you have a lawyer representing, they can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to call witnesses. What that means is that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have what is called a Fifth Amendment right against self-incrimination. I'll explain that to you. The Fifth Amendment of the United States Constitution gives us the right to remain silent. And that's, we don't have to say nothing, right? The state can't call you to the witness stand to testify against yourself. If you invoke your Fifth Amendment right or exercise your Fifth Amendment right against self-incrimination. I know a lot of times we watch television like Law and Order, and we might see a television lawyer go up to the witness stand to ask somebody a question. The person say, I take the fifth. Okay? That means I'm not saying nothing. I have a right not to say that. I ain't saying I take the fifth. Okay? You have a right to do that. All right? That's called the Fifth Amendment right against self-incrimination. Now, you can waive or give up that right if you want to. If you do, then you'll be taking the witness stand. Now, the other right that you have a right to have discovery. And I'm going to explain what that means. So where it says discovery, it basically means you have a right to see the evidence that the state has and will be using against you. You have a right to look at that file. You have a right to see your witness statements, your statements, police reports, lab reports. You have a right to see photos, video recordings, listen to audio recordings. You have a right to see the documents. You have a right to see instruments, whatever they have. You have a right to have access to that. All right? To prepare for trial. Now, you can waive or give up your right, which means that if you waive or give up your right, then you will not be having access to it. Okay. Now, everyone that's here for a case, you've been charged, arrested, placed in jail, and you're out of jail on bond, either cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you pay the bondsman a percentage of the bond to get out of jail. Or you might be out of jail on a PR bond or personal recognizance bond, which means you didn't have to pay nothing to get out of jail. You were just released under your own personal recognizance. Now, I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. So, for example, let's say you spent 5 days in jail. And let's say you in the state or you or your attorney in the state have been talking, and the state is offering that you serve 5 days in jail. What that means is you don't have to serve no more time in jail because you'll be given credit for the time that you've already served. You'll be given credit for time served. Now, if you serve 5 days in jail and they offer 7 days in jail, what that means is you only have to serve 2 days in jail because you have credit for 5. We'll take 5 from the 7 and leaves 2. Now, the state might be offering you fine and court costs. And if you spend 5 days in jail, every day that you spend in jail, you get credit, you get $100 credit towards your fine and court costs. So if you spend 5 days in jail, that's $500 credit that can go towards your fine and court costs. So if the state is offering you fine and court costs of $500, you know what that means? That means you don't have to pay anything because the 5 days you spent in jail has already paid it off, and so forth. And so therefore, it will be taxed and retired. You won't have to pay it. Now, if the state is offering fine and court costs of $700, you spend 5 days in jail, which is $500. We'll take the 5 from the 7 and leave $200. And you'll be required to pay that on the day that your case is taken care of. Now, if you cannot pay it, no problem. Because the court, the judge can convert your fine and court costs to community service. You will receive $12.50 for every 1 hour of community service that you perform in a nonprofit organization. So, for example, in an 8-hour day, that's $100. So if you work 8 hours of community service, that's $100. So in our scenario, you work 2 8-hour days, that's $200, and you finish with your paying your fine and court costs. All right. Now, Jefferson County District Attorney's Office has a program that is called pretrial diversion. That program is for people who haven't been in trouble before. If you haven't been in trouble before, your first time getting in trouble, with that program, they will dismiss your case. And you can get it removed off your record. We call it expunction. Now, in order for you to be eligible, it has to be your first time getting into trouble. It cannot be an offense for unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to help you or assist you with the application process. If those things happen, if those things occur, and you get into the program, they will dismiss the case. And once you complete the program, you can get it expunged, which is removed, deleted, or wiped off your criminal record. Okay? Now, as part of that program, they have what is called the BIP program, Battles Intervention and Prevention Program, and they have anger management. Those two programs are for people. Battles Intervention and BIP is for family violence. You have a assault family violence case, you can participate in the BIP. It's under the pretrial diversion program. Or if you had an assault case without a family member, it'll be under anger management. The same thing. Participate in those programs, complete the program, case dismissed. You can get it expunged or erased, deleted, or wiped off your record. Okay. And we have Johnny Stewart, who is here from Family Services. He's going to come in a few minutes and tell you more about the Battles Intervention or the BIP program. Now, the next thing, if you are a veteran of any one of the branches of the United States military, the District Attorney's Office has a program that is called Veterans Court. It's for veterans only. You get in the program, complete the program, they will dismiss the case, and you could get a non-disclosure where your record is sealed to the general public. This court, County Court at Law Number 2, has a program that is called the Community Safety Initiative, or CSI program, which stands for Community Safety Initiative. With that program, we have partnerships in our community. And the reason why we have the partnerships is because with the program is designed to address the issue of what we call recidivism. Big word that simply means people commit crimes over and over. Okay. And how do we address it, or how do we prevent that? Well, we address it through our community safety initiative, and we have partnerships with local agencies. One of the agencies that we have a partnership with is the Spindletop Center, and we have 2 individuals here from Spindletop. They will come and tell you a little bit more about the program that they have to offer. But basically, with Spindletop, what they'll do, they have the ability to do a private interview either in our jury room, at their facilities, by telephone, whichever is convenient for you. They can also do an assessment to determine what your mental health needs may be, and they can develop a treatment plan for either outpatient or inpatient treatment. Now, in order to qualify for the program, you do not have to be mentally ill. You do not have to be insane or incompetent. You can just merely suffer from anxiety, depression, or any other host of mental illness. And they have the expertise to not only diagnose, but to address and treat your mental illness. Now, if you have issues with alcohol or drugs, Spindletop also has a program that is called ATAR. ATAR is an acronym that stands for, it's ATAR, an acronym that stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR. An acronym is OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do is they can do a screening, an assessment, and develop a treatment plan. Now, if you're unemployed or you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE, and it stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in any one of those areas, they will help you to get a job in the area that you're trained in. Now, if you have not graduated from high school, or if you do not have a GED, well, CICE has a GED program where you can get your graduate equivalency diploma, your GED. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this school, we do not just give time, we take our time. That simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community. And if we make a difference in if we make a difference in the community, then we'll produce productive people. Because what comes out of the home goes into the community. And so if we make a difference in the home, we will make a difference in the community. And so if you're interested in any one of these programs, just let us know. And we'll be happy to assist you in getting in any one of these programs. And as I mentioned to you earlier, none of these programs does not cost you anything but a little time. All right. Now, I mentioned to you earlier that we have some folks here from Spindletop. They're going to, come and tell you a little bit more about the program that we have. We have Deputy Otis and we have Caitlin. They're going to come and tell you just a little bit more about the program that Spindletop has to offer.
Thank you.
You're welcome.
Good morning, everybody. I'm Deputy Butler with the County Sheriff's Department. One of the lead meetings on the officers, Spindletop. All of you got that little form, most of you have the little form and have to fill out. It's a form that you're not being forced to fill out, it's your choice, if you want to fill out or not, okay? We have a trend of crime is happening in our city and throughout the United States. And part of the reason we're starting to find out is because there's some type of lack of resources, maybe in the home or lack of resources in the life. Or it could be something that, the disturbance is going on in your life or in somebody's life that cause someone to want to commit such a crime. Well, my partner here, Mrs. Caitlin, she's a qualified mental health professional. Well, like the judge stated earlier, you don't have to be mentally ill to get involved in this program. It's not saying that you lost your mind or you have no type of intellect thinking for yourself. It's just another program that we offer to assist you in any way that we can, of course, helping you outside the court. But if you want to get yourself involved in this type of situation, okay? Like my partner, Ms. Caitlin, she'll explain to you more the reason why we're here.
So the paper that I passed out to you, I'm gonna explain how to fill this out and what it's for. At the top of it is basic information. It's your name, your phone number, your address, your email. We need those things to contact you and to put you into our system. Underneath that is how would you like to be contacted, and the options should be call, text, or email. Whatever you check on that box is how I will contact you. I will not contact you unless it's checked over those boxes. Underneath that should be resources that you need help with. And most of them, if you check it, I send you an email of a form that you have to fill out or a link you have to follow the directions to get that resource yourself. But if you were to check mental health, which could be PTSD, depression or anxiety, or substance use, which could be any type of drug or alcohol, then we can get you into Spindletop services and we can get you the resources and the support that you need for that service. Everything else is pretty much self-explanatory. If you check mental health or substance use and you want to get to Spindletop services, you can write, please talk to me today on your paper if you want to talk to me in person. And when the judge is through with you, I'll come get you. I'll pull you to a back room where we can talk privately. If you'd rather I call you today, then put on your paper, please call me today. If it doesn't matter when I get to you this week, then you can check one of the boxes and I'll get to you before Friday. Like you said earlier, this is not a court form. You don't have to fill this out if you do not want to. You can just turn it in blank. This is just a way for us to reach out to the community and to help. You don't have to, like you said earlier, you don't have to be crazy out of your mind. Like some people think that this is for, it's not. A lot of people go through things and we try to help give the type of resources and the coping skills that you can to be better. This is what this is for. If you're not comfortable talking with just me or just him, we can always switch. It doesn't matter who you talk to as long as you talk to them. Okay. Thank you guys.
Okay. At this time, we'll have Johnny Stewart. Thank you.
Thank you, Judge.
You're welcome.
Good morning. I'm Johnny Stewart. I'm with Family Services. You may have heard about the Women's and Children's Shelter, but we also provide other services too. One of the services is the BIP program, Adverse Intervention and Prevention Program. We used to call it Domestic Violence Prevention Program, but they changed it. This program is 18 weeks. It's 2-hour groups, one group per week. If you have your charge is concerning family violence, this is one of the pretrial diversion programs that's being offered. We have the men's and women's group. So we have 2 women's groups and we have 4 men's groups. We also have Zoom groups in case you're working or out of town. So this take advantage of this program.
you're in here for that, because we are concerned with changing behaviors. You know, you're in here, or you may have been arrested for a charge of domestic violence or family violence. We want to prevent you from having to come to this court again or any other court. That's what the program is about. Giving you tools, giving you, information on how to change those behaviors. And that's what it's all about. And take advantage of this program. Also, if you're a victim of domestic violence, or you know someone's a victim, we also have a non-residential treatment services in the district fire right over here. So we're offering these services not only for the perpetrators, but also for the victims. But I really appreciate you guys listening to me, and if you have a chance to take advantage of this program, do so. Thank you very much. Judge, thank you very much.
Okay, thank you, Johnny.
All right.
Okay, ladies and gentlemen, we're gonna be going into a recess for a few minutes to give you time to finish filling out the paperwork. Once you finish filling out the paperwork, we will pick it up. And I say we're talking about the court personnel. If you need help with the paperwork, just let us know, just raise your hand, and our court personnel, including myself, will be happy to help you finish filling out the paperwork. Now, it's gonna take a few minutes to pick up the paperwork from everyone. And if you need to use the restroom, there are two restrooms that's right outside in the hall. The men's restroom is in front of County Court at level 3, and on the opposite side of the hall, you'll find the women's restroom. You'll be allowed to use the restroom. Now, please do not leave the courthouse. If you leave the courthouse and we call your name, you're not here, you warrant, well, your bond can be forfeited, and if your bond is forfeited, a warrant will be issued for your arrest. Then that simply means that you'll be arrested, placed in Jefferson County Jail, you have to bond out, and then we have to go through this whole process all over again. So it's gonna take us just a few minutes to pick the paperwork up, assist you with filling out the paperwork, and then once we finish evaluating the paperwork, we're gonna put you in one or two groups. One group is you want to hire an attorney. Second group will be you would like to apply for court-appointed attorney. Third group is you would like to represent yourself. Now, if you would like to represent yourself, you'll have an opportunity to talk to one of the prosecutors this morning to see if you can work out a settlement in the case. Now, if you are applying for court-appointed attorney, you will, and if you qualify, you will be given a court-appointed attorney this morning. Okay? And so, if you have any questions, just let us know. At this time, before we go into recess, I need to remind you that we are in court. Please conduct yourself accordingly. If you need to go outside in the hall, you can, but I think what we want you to do is finish filling out the paperwork first, turn it in, and then you can go out, and then we're gonna call everyone back in. Now, at the top of that document, judge's explanation, you'll see a line, it says state of Texas versus blank. Print your name on that line. Okay, so we'll know, because sometimes we get those documents back, and they, at the bottom, it had the signature, you can't read what it says. So print your name at the top on that line, okay? So at this time, we're going to go into recess, and those individuals who need some assistance with filling the paperwork, just raise your hand, and then we'll either ask you to come up here, or we'll come out and help, okay? Okay, the court will be in recess. Jefferson County Court Docket Number 2 is back in session. The court is in session with its arraignment docket. First case is cause number 25 CCCR 0920. I'll repeat that. It's cause number 25 CCCR 0902. Case is styled the state of Texas versus Tremonte Moulton. Mr. Moulton, would you please come forward? And Mr. Moulton, your full name is Trevante Marquise Moulton. Moulton, would you please raise your right hand? Mr. Moulton, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Moulton, you may put your hand down. How are you doing, Mr. Moulton? That's good. Now, Mr. Moulton, I have before me a document that is titled Misdemeanor Judge's Explanation of Rights to Defendants Without Attorneys. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you have, you hired attorney Marvin Lewis?
Yes, sir.
Is everything on this document true and correct to the best of your knowledge? And you read everything in this document before you signed it? You understood everything?
Yes.
Okay. Now, Mr. Moulton, your case is going to be reset to give Mr. Lewis an opportunity to submit to the court a letter of representation. And our court reporter is going to reset your case, but before she resets your case, I need to give you some bond conditions. Would you please step to the side so I can hand these bond conditions to you? You can step back in front of the bench. I'm going to go over these right in the bench right here. I'm going to go over these bond conditions, which in it states, following return of criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol. And the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? Okay. Condition number 3 and condition number 4 does not apply. However, condition number 5 does apply, and it states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, Mr. Moulton, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Please stand in front of them. You already did his?
Yeah.
Okay, please have a seat in that first chair on the wall. Once she calls your name, you go back up to the window. And once you're finished, you're free to go and you have a blessed day. Jesus Alberto Silva. Stay here, must be locked, so. Now, Mr. Silva, your full name is Jesus Alberto Silva? Mr. Silva, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Silva, you may put your hand down. How are you doing, Mr. Silva?
Pretty good. How about yourself?
Fine, thanks for asking, Mr. Silva. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And
First.
are these your initials on the line that state you would like to have your case reset to hire your own attorney?
Yes, sir.
Mr. Silver, before you signed and initial this document, did you read the document?
I couldn't fully understand this, should have asked more questions though, but.
Well, let me ask you, now, a few minutes ago, I went over every last one of these documents with you. You remember that?
Yes, sir.
Did you understand everything that I went over?
I understood the part that if I hire an attorney on my own, I would like to do that, sir, but.
Okay, so, you understand you had a right to have an attorney.
Yes, sir.
And if you, wanted to hire an attorney, you can hire an attorney.
Yes.
And if you wanted to, a court-appointed attorney, you can request a court-appointed attorney to be appointed to represent you. You understood that?
Yes, sir.
Did you understand that you could also waive your right to an attorney and represent yourself?
Yes, sir.
And you understood that, that is a disadvantage of self-representation, waiving your right to an attorney representing yourself may result in a worse outcome for you in your case, including the loss of significant rights and opportunities related to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Did you understand that?
Yes, sir.
Now, you understand that if you did decide to represent yourself, you could change your mind at any time and request that an attorney be appointed to represent you.
Mind if I speak freely, sir?
Hmm?
Mind if I speak freely?
I mean, okay, yes.
When I was in county, I had told them if I wanted a court-appointed lawyer, and they told me I make too much, so.
Okay, well, you're not in county now,
Okay.
but you have to go with your current situation. So my question to you on this document, did you understand everything that I just went over?
No, I do, sir.
Okay, now you place your initials on a line that is titled, that states you like to waive your right, that you would like to hire your own attorney. Is that correct?
Yes, sir.
And is this your signature online as cited defendant? Now,
Yes, sir.
is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Mr. Silva, your case is going to be reset to give you an opportunity to hire your own attorney.
Mhm.
But before our court coordinator give you a reset, the bailiff is going to give you a document that is titled Standard Bond Conditions in County Court Law Number 2. I'm going to go over these bond conditions with you. And that document that has just been handed to you states, as a defendant in a criminal case, you have three options. Oops, excuse me, go to the other. It states that standard bond conditions in County Court Law Number 2. Following return of a criminal information in County Court Law Number 2, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. On that document, it says, number 1, the defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that
Yes, sir.
condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that
Yes,
condition?
sir.
Now, condition number 3 and condition number 4 on page 1 does not apply. However, condition number 5 on page 2 does apply. And condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07, the penal code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Silver, if you violate any one of these conditions, your bond will be revoked. And if your bond is revoked,
Mhm.
a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Now, your case is going to be reset. Please have a seat in that first. Okay, you can go to the window. She's going to give you reset. Once she gives you reset, you're free to go and you have a blessed day.
You too, sir.
Thank you. Denise Rodriguez. Okay. This is cause number 25 CCCR 0978. Case is style of state of Texas versus Denise J. Rodriguez. Ms. Rodriguez, is that your full name?
Yes, ma'am. Yes, sir.
How are you doing, Ms. Rodriguez?
I'm good. How about you?
I'm doing fine, thanks for asking, Ms. Rodriguez. I have before me two documents. First document states that it's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that is titled that states you would like to apply for court-appointed attorney?
Yes, sir.
Ms. Rodriguez, did I swear you in? Ms. Rodriguez, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Ms. Rodriguez?
I'm good.
That's good. Now, Ms. Rodriguez, is everything in this document that I just showed you true and correct to the best of your knowledge?
Yes.
I'm gonna show you another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature on the line that is titled defendants.
Yes, sir.
And is this your signature up here? Now, Ms. Rodriguez, before you signed and initialed all of these documents, did you understand did you read the documents?
Yes.
Did you understand what you read?
Yes,
Is everything in these documents true and correct to the best of your knowledge?
yes, sir.
Ms. Rodriguez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Tom Burbank. Attorney Burbank will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you will be free to go and you have a blessed day. And I see that you expected.
Yes.
You praying that you have a healthy baby
Thank you.
and you have a healthy delivery.
Thank you.
Okay, please have a seat in that chair on the wall. Dennis Miller. Okay, Mr. Miller, would you please raise your right hand? Mr. Miller, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Mr. Miller, you may put your hand down. Mr. Miller, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. But before we get into this document, Mr. Miller, how are you doing?
Okay.
That's good. Now, Mr. Miller, on this first document, Judge's Explanation of Rights to Defendants Without Attorney, do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes.
Or are these your initials on the line that state you like to apply for court-appointed attorneys? I have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes.
On page 2 of this same document, there's a set of initials on the line. Well, there's a signature on the line that's titled defendant signature. Is this your signature?
Yes.
Now, Mr. Miller, before you sign and initial these documents, did you read the documents?
Mm-hmm.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
I guess the information on indigents is estimated.
Okay. Okay. Now, Mr. Miller, I've read your answers on these documents. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Reuben Cartwright. Attorney Cartwright will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go. You have a blessed day. Please have a seat in that second chair on the wall.
Right.
Caitlin Van Deur Van Duren? Ms. Van Duren, the full name is Caitlin Van Duren. Ms. Van Duren, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Van Duren, you may put your hand down. How are you doing, Ms. Van Duren?
I'm good, how are you?
I'm doing fine, thanks for asking, Ms. Van Duren. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
You have another document that is titled Jefferson County Affidavit of Indigenous. Do you recognize this document? On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Van Buren, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Van Duren, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Christy Carter. Attorney Carter will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. John Henry. Mr. Henry, your full name is John Truman Henry Jr.?
Yes, Your Honor.
Mr. Henry, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Henry, you may put your hand down. How are you doing, Mr. Henry?
Fine, sir. Very good.
I'm doing fine, thanks for asking. Mr. Henry, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, Your Honor.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, Your Honor.
Have another document that is titled Jefferson County Affidavit of Indigenous. You recognize this document?
Yes.
On page 2 of this same document, there's a signature above the line that's titled Defendant's Signature. Is this your signature?
Yes, Your Honor.
Mr. Henry, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
Yes, Your Honor.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Henry, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. The attorney that will be appointed to represent you in this case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go and you have a blessed day. Please have a seat in that third chair on the wall.
Bless you too, Your Honor.
Thank you. Henry Alexander. Ms. Alexander, your full name is, Ms. Alexander, your full name is Henry Lee Alexander?
Yes, sir.
Okay, Mr. Alexander, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Alexander, you may put your hand down. How are you doing, Mr. Alexander?
Good.
You doing good? That's good. Now, Mr. Alexander, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Mhm.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you'd like to apply for court-appointed attorney?
Yes, sir.
Also have another document that is titled Jefferson County Affidavit of Indigenous. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Okay, Ms. Alexander, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Alexander, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Giles Cole. Attorney Cole will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in the second chair on the wall. Dwayne Isaac. This is cause number 25 CCCR 0994. Case is styled the state of Texas versus Dwayne Isaac. Mr. Isaac, is that your full name?
Yes, sir.
Mr. Isaac, would you please raise your right hand? Mr. Isaac, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Isaac, you may put your hand out. How are you doing, Mr. Isaac?
I'm doing good.
That's good, Mr. Isaac. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled
Yes,
Defendant?
sir.
Or are these your initials on the line that state you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that is titled Defender Signatures. Is this your signature?
Yes, sir.
Now, Mr. Ajit, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge?
Yes, sir.
Mr. Isaac, I read your answers. Based on the answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you. You will be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over this document with you.
Mhm.
And it states, following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court, and the court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Question, Judge. But what if I cash my whole bond out?
Which mean you cashed
Like
it.
my whole bond? I don't got no bond.
You're on bond. If you wasn't on bond, you'll be in jail.
Like I paid the whole thing out though.
Okay, but you just, that was a contract you had with your bondsman. But it's a cash bond, so they still holding your bond. You haven't got your bond back. You only get your bond back when this case is over. So you're currently on bond. The money you paid is for you to be on bond,
Right.
and you are on bond.
Right. I see what you're saying.
Okay, so these are conditions of your bond. Since you're
Right.
out on bond, the conditions of your release is you are required to adhere to these conditions. Do you understand that?
Right.
Okay, so condition number 2, do you understand condition number 2?
Yes, sir.
And condition number 3 states that defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. However, condition number 5 on the second page does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Okay, now, Mr. Isaac, if you violate any one of these conditions, your bond will be revoked, and if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, Now, move down to chair number 2, and you have a seat in second chair. You can move to chair, yeah, you go to chair 1. Well, I can't answer any questions about your case. And I can't give you any legal advice, because as a judge, we can't give legal advice.
No question. Is it possible to do like a zoning code?
Oh, yeah, are you talking about, your attorney will tell you that. I mean, we have, in certain occasions, you're allowed to use Zoom. Okay. James Edward Mitchell. Take me a minute to pull your case up on this computer. Well, this is it, appeal? Right. There's a- there. Okay, it's complete. Office. Okay. This is cause number 25 CCCR 1044. Case of style of state of Texas versus James Edward Mitchell. Mr. Mitchell, is that your full name?
Yes, sir.
Mr. Mitchell, would you please raise your right hand? Mr. Mitchell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Mitchell, you may put your hand down. How are you doing, Mr. Mitchell?
Doing well with yourself.
I'm doing fine, thanks for asking. Mr. Mitchell, the state is represented in this case by Attorney Shane Hilton. Attorney Hilton, how are you doing?
I'm good, Your Honor. Thank you.
You are. Mr. Mitchell, before we get started, you have a right to have a court reporter to dictate or type down everything that's being said in this proceeding. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
No, I don't. Shoot me.
Okay, so just have a seat. We got to get our court reporter. Okay, just have a seat. Let's see if we get the notes better. Jeremy Reynolds. I'm gonna send this back to you. You can send it. Okay, this is cause number 25 CCCR 1010. Case is styled the state of Texas versus Jeremy Jermaine Reynolds.
Yes.
Is that your full name?
Yes.
Mr. Hilton, are you gonna be handling this case? Mr. Reynolds, Mr. Reynolds, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Reynolds? I'm doing fine, thanks for asking. Mr. Reynolds, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you would like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Enter Guilty Plea of Proceeding and Trial. You recognize this document? Is this your signature on the line that's titled Defendant? Mr. Reynolds, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Now, Mr. Reynolds, before we go any further, you have a right to have a record made by the court reporter. Do you waive or give up the right to have a record? Would you like to have a record? You waive it? Okay. Now, Mr. Reynolds, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jeremy Jermaine Reynolds, on or about March 14th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Mr. Reynolds, do you understand what you've been charged with? And to this charge, Mr. Reynolds, how do you plead guilty, not guilty, or no contest? No contest? Now you pleaded no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Okay, Mr. Reynolds, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document? Okay, let me do this here. There's some initials, JR, on two different lines. You place your initials on this line. First line is nola contingere, which means no contest.
Yes, sir.
And the second set of initials is below a paragraph that is titled Discovery Admonishment, and is on line next to the statement that states, I do not request discovery in this case. I waive my right to discovery and choose to enter a plea of guilty or no contest. Did you place your initials on the second location? On page 3 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement? I also have another document. Well, I don't have another document. Now, Mr. Reynolds, before you sign, here we go, and initial all of these documents that I just showed you, the ones on paper and the one on the tablet, did you understand, did you read everything in these documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Reynolds, are you a citizen of the United States?
The upper state's one.
Now, Mr. Reynolds, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. State's Exhibit number 1 is the first document that I showed you on the tablet. It has your initials on page 2 and your signature on page 3. Is it all right for the state to use this document as evidence in your case? What this basically is saying that everything in this document is true and correct, and you're not objecting to the state using it. Is it all right for the state to use this document in your case? Okay, no objections. State's Exhibit number 1 will be admitted. Mr. Reynolds, are you a citizen of the United States? Did I ask you that? Okay. And is there any evidence that you are currently mentally incompetent to stand trial? That means, is there any evidence that you suffer from a mental illness that affects your ability to rationally understand everything that's going on here and involved your case? Okay, so you are competent to stand trial. Now, Mr. Reynolds, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reason without state. Do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
The agreement in this case is to 1 year deferred probation with a $400 fine and 40 hours community service. The state is crediting 1 day jail credit towards finding court costs in this case.
What is the 277 is court cost? You say 692? So if it's 692, the court cost is 292. Yeah. Okay.
Oh, and state is crediting 1 day towards finding court
Yes.
costs, so.
Yeah, 1 day credit. Okay. Mr. Reynolds, the state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You'll be required to pay a fine of $400 plus court costs of $292. You'll be given credit of $100 toward your fine and court costs, so it's gonna be reduced by $100. You'll also be required to pay a probation fee of $6,000 a month, UNAS with $15 a month, reimbursement fee of $15. Your total monthly installments, that is a total amount that you will be required to pay each month while you're on probation, is $137 a month. Will you be able to pay the $137 each month?
Yes, sir.
You'll also be required to perform 40 hours of community service, and you'll be required to adhere to the other standard terms in this probation. Mr. Reynolds, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? Do you accept the state's offer? Mr. Reynolds, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Reynolds, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to an attorney about the non-disclosure. Okay. Mr. Reynolds, please stand at the end of that table. You're gonna follow the direction of the bailiff. Once you finish following her directions, you'll be free to go, and you have a blessed day. James Edward Mitchell. Okay, we're gonna have a record in this. Did you send Mitchell back to me? Thanks. Okay. This is cause number 25 CCCR 1044, case of style in the state of Texas versus James Edward Mitchell. Mr. Mitchell, is that your full name?
Yes, sir.
Mr. Mitchell, would you please raise your right hand? Mr. Mitchell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Mitchell, you may put your hand down. How are you doing, Mr. Mitchell?
Word.
That's good. Mr. Mitchell, I have before me a document on my computer. Actually, the document is titled complaint. In this complaint that was filed by the Port Arthur, or the city of Port Arthur in Jefferson County, Texas. In this complaint, it alleges that you, James Edward Mitchell, on or about October 28 of 2024, while you in the territory limits of the city of Port Arthur, state of Texas, that you were operating a motor vehicle on a public street or highway in the city of Port Arthur, and you did drive the vehicle at a speed of 62 miles an hour, which was greater than a reasonable prudent under the circumstances then existed. And said the maximum speed of location being 40 miles an hour. Now, do you understand what you've been charged with?
Yes, sir. I do.
To this charge, how do you plead guilty? Not guilty, no contest.
Okay.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
Correct.
Mr. Mitchell, I also have before me a document on my computer that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes, I do.
Now, on page 2 of this document, before I get to the initials, I need to insert something. under the paragraph that is titled waivers. It says information. Insert complaint. Okay, now, Mr. Mitchell. Notice, I'm gonna put my initials there. I noticed I inserted a word here. And the word that I inserted was complaint along the side here. And the reason why I inserted that word, because you're not charged by an information. This is a Class C misdemeanor that it was appealed from Port Arthur City Court, so you're charged by complaint. So I changed it to complaint.
Okay.
All right. Now, there are two sets of initials. First set of initials is below the paragraph that's titled waiver, and it's on a line that is titled no contender, which means no contest. Did you place your initials on this line? Second set of initials is below a paragraph that is titled discovery admonishment, and it is on a line next to a statement that reads, I do not wish to have discovery. In this case, I choose to enter a plea of guilty or no contest. And is this are these your initials?
Yes, sir.
On this line? Specifically, it says that I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Now, on page 3 of the same document, there's a signature above the line that's titled defendant's signature. Is this your signature?
That's it.
And on the next document, that's it. Okay, on the next document, that's titled Jefferson County Trials Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And are these your initials? Well, at the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Right.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement? Now, Mr. Mitchell, before you signed, and it also, I don't think I went over this one. I also have two other documents that's on paper. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir. I do.
And is this your signature on the line that's titled Defendant?
Correct.
Or these your initials on the line that states you like to waive your right to attorney and represent yourself?
Yes, sir.
Another document is titled Waiver of Counsel for purposes of entering guilty plea or proceedings trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes.
Now, Mr. Mitchell, before you sign and initial all of these documents, did you read these documents?
Yes,
Did you understand what you read?
yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
And Mr. Mitchell, are you a citizen of the United States?
State offer States Exhibit 1, Your Honor.
Okay. Mr. Mitchell, the state is offering States Exhibit number 1 to be used as evidence against you in your case. States Exhibit number 1 is the first document that I showed you on this tablet. It is the same document that have your initials on page 2 in the 2 locations. And it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, yes.
No objections. State's Exhibit number 1 will be admitted. Mr. Mitchell, is there any evidence that you are currently mentally incompetent to stand trial? No? Okay, Mr. Mitchell, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we would ask the court for a fine of $100 with repayment of the court costs.
And what's the court cost in this case?
292. It was 287, but they added.
Okay. Okay, Mr. Mitchell, the state is offering that you pay a fine of $100 plus court costs of $292, which comes to a total of $392. Are you able to pay that today?
Yes, I am.
Okay. Now, Mr. Mitchell, do you understand the state's offer?
Yes, I
Do
do.
you think the state's offer in your case is fair and just?
I don't, but
I'm sorry,
I
but
have
it was
a
actually,
choice
we
to
can't
go
go to
there.
387, that was the other one. It came up to 387.
Okay, so it's 287
Right, they
court costs.
charged it, fee that they wanted.
Okay, let me do that. So let me do this. Now, Mr. Mitchell, the state is offering that you pay a fine of $100 plus court costs of 287. So your total fine and court costs is 387, not 392. Do you understand that?
Yes, I do.
And do you, as a, actually again, do you understand the state's offer?
Yes, I do.
And do you-
Also, not to cut you off, but I pay this today, but do I get my cash bond back?
Yeah, once this case is disposed of,
Right,
if you have a
Okay.
cash, you pay the cash bond, you get it back.
right, okay.
Okay, but you have to go downstairs. Now, do you think this is office fair and just?
Yeah, I don't, but,
Do
because
you-
I was told different by the city prosecutor in Port Arthur. And it was like, he was explaining to me that he don't know how it got like that twisted. And
Well,
it's-
yeah, I mean, we wasn't
So-
privy to the conversation. We just know what the law is in your case.
Right,
Okay,
and
Now,
that's what
did-
we gotta go by.
all right. Do you accept the state's
Yes, I
offer?
accept.
Okay, I'll follow the plea bargaining agreement that you entered into with the state. Now, Mr. Mitchell, you're gonna stand next to the bailiff, follow her directions, and then you're gonna go downstairs, make the payment and make your you're gonna bring your receipt back up with,
Okay.
all right?
It's still. We'll give you a
All right.
copy to take you downstairs to get your cash on them.
Okay.
All right, and you have a blessed day.
Yes, sir.
Okay, we have some bond forfeitures, that's it.
Yeah,
Okay. Do we know whether or not, did you? Next case is clause number 24 CCCR 0228. Case is styled the state of Texas versus the Keithia Patrice Holloman. The Keithia Holloman was scheduled to be in court this morning at 9 a.m. At about 9 a.m. The court bailiff called the Keithia Holloman. The Keithia Holloman did not answer. The Keithia Holloman has not appeared in the court since the court has been in session. The time now is 11:33 a.m. on today's date, June 10th, 2025. Ms. Bailiff, would you please call the name of Dekethia Holloman?
Yes, Keith.
Deskethia? Yes. What else? Same. Okay. No answers at the courthouse door from the defendant, Deskethia Holloman. State the court has given Ms. Holloman a reasonable time to appear. She has not appeared. State, do you have a motion?
State will request bond forfeiture, Your Honor.
That motion will be granted. Deskethia Holloman's bond will be forfeited and warranted Bishop arrest in clause number 24 CCCR 0228. Next case is clause number 25 CCCR 0874. Case to style the state of Texas versus Joshua Janis. So we have an attorney rep come in. Okay.
It's too long.
To what? Oh, who's the other person? Is it-
Joshua Janice.
That's that.
And Kenneth Unit.
Okay.
That will power James Pension.
Okay. Okay. Romero Rodriguez. Cause numbers M333742, cause number M 333-744. Oh, they said somebody was in High Tower unit. Is he still in the High Tower?
Oh, that's the one, Judge. You want him to be benched. We need to find that out. Then you said you wanted him to be benched trial.
Bench one.
Bench warrant, I mean.
Get it, yeah. Then let's go to the next case. Next case is Quinchetta Nichelle Cigar. Quinchetta Cigar was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Quinchetta Cigar at the courthouse door. Quinchetta Cigar did not answer. A reasonable time has passed to give her an opportunity to appear in court. She has not appeared in court. The time now is 11:35 a.m. on today's date, June 10th, 2025. Ms. Bailiff, would you please call the name of Quinchetta Cigar at the courthouse door?
Quinchetta Cigar. Quinchetta Cigar. No response, Your Honor.
Quinchetta Cigar name was just called again at the courthouse door. She did not answer. Reasonable time has passed to give Ms. Cigar an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
State moves for bond forfeiture, Your Honor.
That motion will be granted. Quinchetta Cigar bond will be forfeited and warrant should be issued for her arrest and cause number M 328-592. Next case is cause number M 323-710. Case is styled the state of Texas versus Myrick Rynell Taylor. Myrick Taylor was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Myrick Taylor at the courthouse door. Myrick Taylor did not answer. A real time passed to give Mr. Taylor an opportunity to appear in court. He is not appearing in court. State. And the time now is 11:37 a.m. on today's date. Ms. Bailiff, would you please call the name of Myrick Taylor at the courthouse door?
Myrick.
Yes.
Myrick.
Yeah, Myrick Taylor.
Myrick Taylor. Myrick Taylor. No response, Your Honor.
Okay, Myrick Taylor's name was just called again at the courthouse door. Myrick Taylor did not answer. A reasonable time has passed to give Mr. Taylor an opportunity to appear in court. He is not appearing in court. State. You have a motion?
State moves for bond forfeiture, Your Honor.
That motion will be granted. Myrick Taylor bond will be forfeited and warrant should be issued for his arrest. And cause number M 323-710 case. And this will conclude the calling of the court's arraignment docket on today's date, June 10th, 2025, in County Court at Law Number 2, Judge Terrence Holmes presiding. Everyone, please have a blessed day, and prosecutors, you are excused.
Thank you, Your Honor.